I'm Drew Stevenson, and this is a video for my professional responsibility class about lawyer fees and legal ethics. And this is part 2 in my series about Model Rule 1.5. And here I'm going to hit the highlights from the ABA's official comment to the rule. Now, I have a previous video that explains the core provisions of Model Rule 1.5, which governs lawyers' fees. Remember, 1.5a says the fees have to be reasonable. B says they have to be clearly communicated, preferably in writing to the client, explaining things like how the fee will be calculated. Is it hourly or contingent or a flat fee? What percentage and how that will be calculated if it's a contingent fee and so on. If it's a contingent fee, it has to be in writing. That's C. D says you can't charge contingent fees for criminal cases representing defendants or for divorces and child support cases. And E is about dividing fees when lawyers from multiple firms work on a case together or in series, right? So maybe one firm does the trial and another firm does the appeal. And basically the bottom line with that is the client has to agree upfront to every lawyer who's going to be working on it and how the fees are going to be allocated. So having said that, I want to hit the some highlights from the comments. And some of the comments for Rule 1.5 merely restate the rule in other words or explain kind of the policy rationale behind the rules. I would like to focus on the things that I think you're likely to see as a test question on the MPRE or my exam. So first, in comment 1, this is about pass-through costs or getting reimbursed from a client for some of your expenses. A lawyer may seek reimbursement for the cost of services performed in-house, such as photocopying or, let's say, overseas phone calls, either by charging a reasonable amount to which the client has agreed in advance, or by charging an amount that reasonably reflects the cost incurred by the lawyer. In other words, you don't get to have a surcharge or middleman cost or markup on these pass-through costs. To give an example for my students, in law school, you start using Westlaw and Lexis, and that's free for you as a law student. When you get out and practice, it's very, very expensive, and you're going to pass the cost of that typically through to your client if you have to do legal research on Westlaw, let's say, for a client matter. And you have probably already noticed that when you log in, you have to input a client code. That doesn't matter when you're a student, but when you're in practice, it's very important because it tracks, and then you get an itemized bill that's divided. Each client is paying for only the legal work that was done, or the Westlaw charges for their matter. And the same is true with photocopiers, modern photocopiers and law firms. You can punch in a client code before you start making copies, and it tracks it so that each client pays for the exact number of copies and the cost of those copies from that machine. You don't have to divide it up later. If you have to travel to another state to do a deposition or something for a client matter, you can pass those travel costs through to your client, but you cannot charge a markup or surcharge. Long ago, back in 1993, the ABA put out an ethics opinion addressing this, saying you can't have a surcharge, and you're also not allowed to basically prorate your overhead expenses to clients. So you cannot charge a client for overhead expenses generally associated with properly maintaining, staffing, and equipping an office. So can you charge a client for copies that you make for that client's case? Yes. Can you take your secretary or receptionist salary and basically divide it up between the active clients you have in any given month? No, you can't do that. You would have to hire a receptionist or secretary. The thinking is whether you had that client or not. And the same is true with your office rent and so on. You may not charge more than your disbursements for services provided by third parties, like court reporters, or if you send a copy job out to Kinko's or something like that, travel agents, expert witnesses, jury consultants, except to the extent that the lawyer incurs the costs additional to the direct cost of third-party services. So if you have to spend a lot of money tracking down a particular expert witness, that would be a cost that you could pass through to the client. But you can't just charge, again, some of your overhead. You can pass through the bill that you get from a court report, a transcriptionist, or an expert witness through to your client. You may recoup expenses reasonably incurred in connection with the client's matter for services performed in-house. This is the same as what comment 1 says, like photocopying and overseas phone calls, computer research, special deliveries, courier services, let's say. And then here's a tricky one, secretarial overtime. So if you tell your staff, like your paralegals and secretaries, that they're going to have to work on the weekend, which they normally wouldn't do to prepare for a trial that starts on Monday, well, that's all about one client's case. And so their overtime, if you can pin it to one client, is something that you can ask that client to reimburse your firm for. Not their base salary, not their benefits, but their overtime pay. As long as the charge reasonably reflects the lawyer's actual cost, you don't get to charge a markup. Comment 2 says that for clients regularly represented, ordinarily there will have evolved an understanding concerning the basis or rate of the fee and expenses for which the client will be responsible. Remember that 1.5b says that you are supposed to clearly communicate the fee arrangement to the client. But what if you do work for a client on an ongoing basis, right? They just call you every time they have a problem, and so you're kind of almost always doing some work for the client, or you're working for them on and off. Well, if they understand how your fees work and they have been paying your bills and so forth, and it's understood that you are going to do the fee at the same rate, then you can work with that previous understanding. It's a different situation if it's a new client-lawyer relationship, in which case it's very important to promptly establish an understanding about fees and expenses. The best practice in the legal industry is to furnish the client with at least a simple memorandum or document of the lawyer's customary fee agreements. So this should be a document that includes the general nature of the legal services to be provided, the basis, rate, or total amount of the fee, and whether and to what extent the client will be responsible for any additional costs and expenses or disbursements in the course of the representation. Trust me, it leaves a lot of room for misunderstanding and people accusing you of something, remembering things differently when they get a bill later that they didn't understand. It will save yourself a lot of grief if you just put things in writing up front, so you can point to that later if the client disputes the charges. Comment 4 says that is about requiring advance payment. So in certain areas of law, it's customary for lawyers to ask people for a large sum up front, prospective clients. So $10,000, let's say, or $50,000. I've seen lawyers charge that. And this gets put in a client escrow account or trust account. And then as you do your legal work, periodically, every week or 2 weeks or month, you bill that account and basically draw down from that account for the fees that you've incurred up to that point. But remember, if the representation ends abruptly, either because it settles quickly or the client fires you or you quit, you have to return the unearned portion. You don't get to just keep that. That should be obvious, but I see disciplinary actions every month, basically every month in Texas, for lawyers who didn't return unearned portions of the client fees after a client either fired them or the matter resolved more quickly than anyone expected. What about accepting property in payment for services? We talked a little bit about this when we did Rule 1.8 early in the semester. You can accept property in lieu of cash for your fees. So let's say the client signs over a small percentage of ownership interest in their business or in a piece of real estate or something like that, or even intellectual property. They give you a 5% ownership interest in their patents. That's fine, but remember that we have a Rule 1.8I that says you can't acquire a proprietary interest in the cause of action. So if the legal matter itself is about that property or about ownership of that business, then you cannot acquire an interest in that in lieu of as your fee, because it essentially makes you a party in the case. And similarly, remember that if we're paying you in property, like signing a parcel of real estate over over to you, or an ownership share of a business, that is also going to be a business transaction with the client and will be subject to all of the disclosure requirements. Remember, under Rule 1.8a, there's a number of written documents or written disclosures that have to be given to the client for business transactions with your own client. It's also a fee agreement, but it's both. It's a business transaction and a fee agreement. And so because it's a business transaction, it involves a transfer of property or an ownership stake or something like that, you are going to have to comply with 1.8a as well as 1.5. Comment 5 is about prohibits stop work agreements. So once in a while, you'll have a client who wants you to undertake a matter, and they say, I only have $2,000 or I only have $5,000. So I'd like you to do that amount of work. Well, if this is the type of legal work, let's say incorporating a small nonprofit that you would normally do in that ballpark, you can agree to do that. And that's basically a flat fee. What you can't do is do this as a sort of bait and switch where you say, sure, knowing, if it's foreseeable to you, that this is going to be a very complicated matter and you would be withdrawing from the representation very abruptly, sort of midstream. So if it's foreseeable that more extensive legal services probably will be required, you can't cap your fee at an amount that's not going to allow you to complete that. Unless you're going to explain this to the client. And if you can explain to the client, I will do the, let's say, the pre-trial legal work for you for $10,000. Let's say, if it goes to trial, we're going to have to renegotiate a new fee, or you're going to have to go to another lawyer. And if you explain that, that's okay. But what we really don't want is lawyers agreeing to do something, and so the client goes into the representation thinking it's going to cost maximum some set amount, some stated amount, and the lawyer knows full well that they're going to basically be able to play a hold-up game with the client and say, hey, this is much more complicated, so you're going to have to pay me more fees to keep going with the representation. If you knew that ahead of time, then you have to make that clear to the client. All right. This is an important exception that I think you could see as a test question on my exam or on the MPRE. Remember that Rule 1.5d prohibits a lawyer from charging a contingent fee in a divorce matter or on the amount of alimony, support, or proprietary settlement. But what if the divorce was finalized in the past, and you have an existing court order about child support, and then the person in basically someone wants you to sue for delinquent child support? Well, in that case, you can charge a contingent fee because you're not suing for the amount of child support, you're suing to enforce a court order or a settlement agreement, which is sort of like a contract. So the provision does not preclude a contingent fee for recovery of post-judgment balances due under support, alimony, or other financial orders because such agreements do not implicate the same policy concerns. Comment 8 addresses, by saying it doesn't address, the situation of what happens when you do some legal work on a case and then you leave that firm. You move on to another job, let's say at another law firm, and then the legal fees for the matter you worked on come in after your departure. And the answer is the model rules just don't say how much of that, if any, the firm has to pay to someone who's left the firm. That's going to be part of your employment contract when you go work for a firm, whether they will be sending you a check for portions of fees sort of prorated for whatever work you did if the firm keeps going with the matter after you leave. So it's unclear, which means you shouldn't be tested on this. Or if you are tested, you should just keep in mind that this is going to be a matter of contract and is not really answered by the rules. And that concludes the video, my lecture about the comments to Rule 1.5. I have a few more short videos I'm going to make about odds and ends from some court cases and examples and an ABA ethics opinion about legal fees as well.